On behalf of our subcommittee's ranking member, Mr. Rohrabacher, and myself, let me thank Chairman Nadler and his ranking member, Mr. Franks, and their staffs for arranging this joint hearing. Also, let me welcome the chairman of the full committee on the judiciary, Mr. Conyers. Undoubtedly, we shall have subsequent hearings and request the appearance of administration officials to explain their role in the case of Mayor Arah, because justice demands no less. Last April, our subcommittee, along with the Foreign Affairs Subcommittee on Europe, held a hearing where we heard from representatives of the European Parliament who had issued a report that was highly critical of the collaboration of European governments with the Bush administration's policy of so-called extraordinary rendition. They testified that transatlantic relations have suffered as a result, and that this program accounts in no small measure for the low standing of the United States in terms of European public opinion, which we can ill afford. Because, as the Government Accountability Office observed, such adverse foreign public opinion is important. It threatens American national security in 4 ways. By increasing foreign public support for terrorism directed at Americans, by impacting the cost and effectiveness of military operations, by weakening the United States' ability to align with other nations in pursuit of common policy objectives, and last, by dampening foreign enthusiasm for U.S. business services and products. So it's not simply a popularity contest. It's about our vital national interests. For those unfamiliar with the term extraordinary rendition, I'm referring to the practice where individuals suspected of links to al-Qaeda and other terrorist organizations are seized and transferred to countries such as Syria, which, according to the Department of State, systematically and without hesitation utilizes torture. As Michael Scheuer, the former head of the CIA's bin Laden unit, who testified at our previous hearing, said, and I'm quoting him, "It's basically finding someone else to do your dirty work." I asked Mr. Scheuer at that hearing, what about the case of someone who is innocent? His response was, mistakes are made. The rendition of Mayor Arah was just such a mistake, a tragic mistake that, befitting American justice and values, demands acknowledgement and redress. The facts of Mr. Arah's case are profoundly disturbing. Rather than kidnapping someone off the streets in one country and bringing him to another for interrogation, our government took Mr. Arah into custody at JFK Airport on U.S. soil while awaiting a connecting flight on his way home to Canada. The administration would have you believe this is nothing more than an expedited removal under our immigration law. Don't be fooled. This was not simply an immigration matter. He was detained in New York, interrogated relentlessly, and denied an opportunity to make a single phone call for 7 days. Over his objections, and without notice to Canada, he was placed on a private airplane, flown to Jordan, and then driven to Syria, a country he last lived in as a teenager. There he was tortured and kept in a grave-like cell for the majority of his year-long detention. He was never charged with a crime, never given a hearing, never afforded due process as we understand that concept. After the Canadian government obtained his release, it conducted its own review of the matter, consistent with that critical democratic principle of accountability. The independently constituted Iraq Commission spent 2.5 years investigating the matter and produced an exhaustive factual report and policy review. Justice Dennis O'Connor, the commissioner of the inquiry, concluded, and I quote, "There is no evidence that Mr. Arra was ever linked to terrorist groups, and I am able to say categorically that there is no evidence to indicate that Mr. Arra has committed any offense or that his activities constitute a threat to the security of Canada." Based on the Commission's recommendation, the Canadian government apologized to and compensated Mr. Arra for its role in the rendition. That role involved providing raw intelligence without caveats to the U.S. government that identified him as an Islamic extremist suspected of being linked to al-Qaeda, an allegation which had no basis in fact. However, there was no evidence that Canadian officials participated or acquiesced in the American authorities' decision to detain Mr. Arra and remove him to Syria. Therefore, the Commission, the Iraq Commission in Canada, recommended that Canadian officials request that the U.S. government apologize and remove Mr. Arra from its no-fly list. But when faced with such a request from one of our closest allies, the Bush administration did neither, nor did they provide an explanation for its decision to send Mr. Arra to Syria rather than Canada, as he had requested. This provoked outrage, understandably so, in Canada. And according to another poll, a staggering 71% of Canadians hold a negative opinion of U.S. foreign policy. And is it a coincidence that shortly after this poll, Canada refused to participate in the expansion of our ballistic missile defense system? The government of Prime Minister Martin notified the United States that while it would continue to be part of the NORAD warning system, it would not be taking part in that expansion. The refusal of the Bush administration to be held accountable stands in sharp contrast to the actions of the Canadian government and is an embarrassment to many of us. I would note the testimony of former Attorney General Gonzalez as especially appalling. He stated that Mr. Arra's removal to Syria was legal since we had received diplomatic assurances from Syria that Mr. Arra would not be mistreated. From Syria, the same country that President Bush cited for its legacy of torture, oppression, misery, and ruin, and that the State Department routinely condemns in its yearly country reports for torture. Let me suggest that that is the height of hypocrisy. A country that we condemn for torture, we trust to abide by a pro forma, unenforceable diplomatic assurance not to torture. We've betrayed our core values in this matter, values that Americans and Canadians share, values that set us apart among the family of nations and gives us a claim to moral authority inherent in great democracies. So, Mr. Arra, let me personally give you what our government has not, an apology. Let me apologize to you and to the Canadian people for our government's role in this mistake. We regard Canada as a true and trusted ally and friend. My hope is that this hearing will demonstrate our commitment to those shared values that bind us together in this special friendship. Before introducing our witnesses, let me turn to my friend and ranking member on this subcommittee, Dana Rohrabacher, for his opening statement, then to Chairman Conyers and Chairman Nadler and Mr. Frank. Dana.
Thank you very much, Mr. Chairman, and I do appreciate you holding this hearing. After all, when our other witness said mistakes are made, it is our job in oversight to take a look at those mistakes. And this obviously, we are looking at one of those mistakes, and I would hope sometimes we might have a chance to look at some of the successes of the program as well. But this is a mistake, and I would join you in offering an apology, and I would hope our government could do so officially for making a mistake and not owning up to it. When we make mistakes, we should tell the truth and own up to it, and today we are making sure that we go on the record so that our executive branch is on notice that, yes, we believe that a mistake was made here and that an official apology as well as perhaps some compensation is justified. And however, let us note that this is an opportune moment to be having a hearing on the issue of rendition because it just happens to be the subject of a movie that is about to come out. What a coincidence. So today we will hear in great detail about this tragic mistake and this tragic case of Maher Arar. He is a citizen, a dual citizen of Syria and Canada. He was on his way home to Canada from a trip to Tunisia, where he was stopped at JFK Airport, and this is important, in September of 2002. I'm not sure, Mr. Arar, I'm going to be asking you exactly what date that was in September, but let us note that how close that was to 9/11. The Canadian government had told our FBI that Mr. Arar was under investigation for possible terrorist activities and ties to al-Qaeda. Further, they said Mr. Arar had refused to cooperate with the Canadian authorities, that's what they said to us, and had suddenly left the country for Tunisia. We now know that our FBI was given erroneous information. Today we see this tragedy for what it is, a probable mistake caused by human error, resulting in the heartbreaking ordeal of Mr. Arar. So, we need to make sure that we acknowledge that and offer our apologies and make sure that the other people who work for our government know that we expect a higher level of expertise and responsibility than to permit these type of mistakes to be made, realizing that in any human endeavor there will be such mistakes. But let us not ignore, while we're looking at this mistake, that what was going on at that time, which I just mentioned. This was 1 year after the most brutal and bloody foreign attack on American soil in the history of our country. 3,000 of our citizens, less than a year before, had been slaughtered in front of our face. Our government then had in custody a man who the Canadian authorities were telling us was probably a terrorist with al-Qaeda connections. To complicate the situation, the Canadian government informed our FBI that they didn't have enough evidence to charge him with terrorism. Thus, he would most likely go free if returned to Canada. So, our government rendered him to his other country of citizenship, which was Syria. And as we will hear today, Mr. Arar's experience in Syria was a nightmare, was something that, yes, the Syrian government should be ashamed of, and yes, we should be ashamed that we had something to do with that as well. My friends on the other side of the aisle believe that the rendition program must be stopped because of errors like the one that led to Mr. Arar's ordeal. To them I ask, should we halt every government program that, due to a human error, results in a tragedy? Consider this. A recent study of our health care found that 195,000 Medicare deaths per year are completely preventable and due to human error. Mr. Chairman, this is not a case of one person's tragedy resulting from bureaucratic error, but hundreds of thousands of people die because of human error in the Medicare system. Thus far, I haven't heard anyone ever suggest that that means we should end this whole government involvement in taking care of our senior citizens' health care. Another example, just in the past 2 months, UN peacekeepers have been killed or wounded by friendly fire in peacekeeping operations in East Timor and Lebanon. Last year, 4 UN peacekeepers were killed by friendly fire in Israel, and 9 were killed by likely friendly fire in the Congo. Have our friends on the other side of the aisle been calling for an end to U.S. peacekeeping missions? Is that something that we should take as the lesson when we have errors like friendly fire and other human errors that happen and mistakes that happen and downright bad judgment that happens when involved in this type of government program? No, we don't do that. We haven't, for example, put the dead families of these deceased peacekeepers in front of committees to advocate that we end peacekeeping missions. No, we shouldn't, and we shouldn't do that. But we should recognize the errors that have been made and try to correct them, but realizing that an error in a program does not mean that program in and of itself is a wrong program. In fact, Mr. Chairman, when we become aware of the dangerous or deadly errors in government programs, we should do our best to fix those programs and minimize those errors. We should keep such programs alive because we believe that whatever programs we're talking about, including our military operations overseas, which always result in friendly fire, some friendly fire casualties, but we must not cancel programs or missions which we believe are important for the safety, security, and well-being of the people of the United States and, yes, the world. Today's hearing is an attempt to do away with rendition. That's my interpretation. Maybe I'm wrong. We'll have to let me know whether or not that's a wrong interpretation. A government program, rendition, is used to fight our war against radicals who want to end our way of life and are willing to murder thousands, if not millions, of civilians in order to terrorize the populations of the Western democracies into retreat and submission. Those of us who want to end this program will use Mr. Arar's tragic case, which resulted from government error and error of those people who are involved in the program, to prove that the rendition program has no merit. As I say, we do have to, number one, admit the error, also understand that this was 1 year after 9/11. But I challenge anybody to compare the error rate of rendition, this program, with the error rate in any other government program. And yes, it did result in the horrible circumstance with this individual that we're talking to today. And we should make sure that we offer our apologies and recognize that and try to make our system more efficient. But yet, the rendition program may actually be more effective than programs that cause the death of many other and many more people. As we are embroiled in an historic struggle against an enemy that is committed to destroying our way of life and murdering our citizens to terrorize our populations, we are using rendition to stop them, and it works. There has not been a single major terrorist attack on America since 9/11. I would suggest that that isn't just a coincidence that we have a rendition program that was obviously in play 1 year from 9/11 because of what we're hearing today, and the fact that the radicals who have already declared that they are willing to commit this and shown that they are willing to slaughter Americans have not been able to succeed in doing so. There's no such thing as perfection. And when you're dealing with human beings, to cut off a valuable tool in this war against radical Islam because of human error is foolish and is dangerous. We are dealing with an enemy who does not honor treaties, an enemy who has but one code of ethics: destroy America and Western civilization. They do not wear uniforms on the battlefield, they do not identify with any country of origin, and they care nothing for diplomacy or human life, let alone the conventions or treaties that will be discussed today. I support the honest efforts of my friends to put forth any type of effort to improve the rendition program and to admit mistakes and to offer apologies when mistakes are made. But that, again, is no reason, is no excuse to end a program which has perhaps protected the lives of hundreds of thousands, if not millions, of Americans and people in the Western democracies. Thank you very much, Mr. Chairman.
Thank you, Mr. Rohrabacher. And I'll call on the chair of the full committee on the judiciary, Mr. John Conyers of Michigan.
Thank you very much, Chairman Delahunt. What a privilege this is to have two subcommittees working on a subject as important as this. And what a unique collection of members from both committees that are here. The chairman, the distinguished ranking member from California, Dana Rohrabacher, Mr. Trent Franks of Arizona, Constitution Committee Chair Jerry Nadler of New York, Mel Watt of North Carolina, also on Judiciary Committee, and the distinguished gentleman from Arizona, Jeff Flake. I know that this is going to be quite meaningful, and I'm also pleased to join in welcoming Professor David Cole, a judiciary regular, and I'm glad that he's here as well. To the ranking member, I was preparing some comments of praise when he began his statement, because it's so pleasing for me to find ourselves, Mr. Rohrabacher, on the same page. But as your comments went on, I decided in the interest of honesty that I wouldn't offer any congratulations at this point. But I do hold out a hand of cooperation to work with you and to see just how far both of these committees are willing to move in this regard. I'd like, Mr. Chairman, to put into the record by unanimous consent the New Yorker article dated February 14, 2005, outsourcing torture.
Without objection.
Today we consider extraordinary rendition, and for years the administration has repeatedly denied that it engages in this practice, and when it has been asked about these cases, it has acknowledged that it has transferred individuals to foreign states, but argues that such transfers comply with U.S. legal obligations because they obtain assurances from receiving countries that individuals will not be tortured. Nevertheless, a multitude of cases have been made clear that despite this stated policy, this government is sending people to other countries to be tortured. And there are a number in addition to the witness that is here today. Now, extraordinary rendition presents some critical problems. First, it violates the international law prohibiting torture. The United Nations Convention Against Torture and the Degrading Treatment or Punishment, a treaty ratified by our country in 1994, explicitly prohibits the transfer of persons to countries where there's a substantial likelihood that they will be tortured. notwithstanding the fact that the United States is required by law to abide by this convention, pursuant to an implementing statute, Title 22 U.S. Code, Section 2242, the administration apparently takes the position that it does not apply extraterritorially as a matter of law. Other statutes also seek to prohibit the practice of torture and implicate certain actions by this administration. These laws include the Federal Torture Statute, 18 U.S.C. Section 2340, the Torture Victim Protection Act, 28 U.S.C. Section 1350, and it seems to me that as a nation we must not evade these important legal prohibitions by rendering suspects to countries for torture. I'm reminded of Philip Sands, a very interesting international lawyer, treatise on the lawless world, I believe is the title, that tries to encourage this country and others to do more about working in concert nationally and internationally. Now, the administration's assertion that it's received diplomatic assurances from countries that are not engaging in torture is not only unreliable, but it's insufficient. In fact, these assurances typically are obtained from countries, in fact, where there seems to be a strong likelihood of torture. And consistent with the general practice of this administration, there's no public information regarding the manner in which it obtains these assurances. And finally, the practice of extraordinary rendition severely undermines our nation's long-standing reputation as a standard bearer for protecting human rights. And unless and until the United States respects completely laws prohibiting torture, it cannot, in my judgment, expect other nations to respect those laws as they apply them, I worry, to Americans abroad. The administration's actions accordingly, therefore, place our own citizens at jeopardy. So as a nation, we're appalled at what happened to our witness. Nevertheless, unlike Canada, which issued an apology and damages to Mr. Arar, we assert that he may not even seek redress in our courts. It is claiming that the state secret's privilege outweighs his violated human rights. And so I'm hoping that these two committees will help us reclaim our international reputation for basic human rights or risk squandering the constitutional values upon which the nation was founded. And I thank the chairman for his indulgence.
I thank the gentleman, and now let me proceed to a gentleman who has been passionate about this issue. The gentleman from New York, the chair of the Subcommittee on the Constitution, my friend and colleague Jerry Nadler.
Thank you. This joint hearing of the Subcommittee on the Constitution, Civil Rights and Civil Liberties and the Subcommittee on International Organizations, Human Rights and Oversight tackles an issue that goes to the very heart of what sort of nation we are. Last year, I tried repeatedly to get then Attorney General Gonzalez to answer what I consider the simple question: does our government claim the legal authority to snatch someone off the street and lock them up without a trial, or to turn someone over to another government for the purpose of being tortured? Despite my best efforts, I could not get the Attorney General to answer this question before he left office. I would have hoped that the answer would have been obvious and straightforward. The fact that the Attorney General would not answer it at all combined with what information we now have about this administration's misconduct, is frankly terrifying. Today we look at the administration's covert practice of rendition to torture. That's what we ought to call it, rendition to torture. And in particular at the case of Maher Arar, a Canadian national of Syrian birth who was snatched at Kennedy Airport in New York, locked up in the federal detention center in Brooklyn in my congressional district, and then shipped off to Syria by our government. And in Syria he was imprisoned for a year without charge, held for a year and subjected to torture during his imprisonment. It turns out, according to the Canadian government, which investigated this matter and issued a thorough report, that Mr. Arar is not a terrorist, never was a terrorist, was never a threat to the United States or Canada or to anyone else. And while the Canadian government, to its credit, has acknowledged its role in this injustice, apologized to Mr. Arar and his family and compensated him, our government still refuses to admit that it has done anything improper. In fact, the administration hides behind a wall of state secrets to conceal the facts. Mr. Arar remains on the terrorist watch list and is not permitted to enter the United States, which is why he is testifying here today by video hookup. Now, I heard one of the ranking minority members say that this is a regrettable mistake. I'm glad he admitted it was a mistake. Our government does not admit it was a mistake. But it is worse than a mistake, because our government seems to continue to claim the authority to snatch someone off the street, hide behind the fiction of expedited removal. This wasn't an expedited removal in this case. An expedited removal would have gotten him out of the country and sent him off to Canada. It wouldn't even have been necessary because he was simply in the country to transfer from one plane to another to go to Canada. This was a kidnapping. This was a kidnapping utilizing the fact that he was here in this country, or at least technically not in this country, at Kennedy Airport, in order to get him into custody so that he can be sent to someone who does not have our scruples and our laws about torture. It is a testament to Mr. Arar's character and commitment that despite understandable misgivings about ever returning to the United States, he nonetheless agreed to allow us to seek permission from the administration so that he could testify here in person today. The administration refused. For that reason, Mr. Arar will have to testify via satellite hookup from Canada. I cannot recall another occasion in which the Congress has had to go to such great lengths to get relevant testimony from a witness. On behalf of my fellow citizens, I want to apologize to you, Mr. Arar, for the reprehensible conduct of our government, for kidnapping you, for turning you over to Syria, a nation that our own State Department recognizes as routinely practicing torture. I also want to apologize for the continued, and from everything I've seen, some of which I'm not at liberty to discuss, a baseless decision to maintain the fiction that you are a danger to this country. This conduct does not reflect the values of the American people. The great secrecy employed by the administration is, I believe, less an attempt to protect our security than it is an attempt to protect this administration from the consequences of its actions and from the consequences of being held accountable at law for what it has clearly done in breaking the law. There's no excuse for that. Now, we are told that the administration, rather than let Mr. Arar go to Canada, where he would be set free because the Canadian government said they didn't have enough evidence to hold him in detention for any crime, and maybe he would therefore pose a threat to the United States, according to the administration, they decided to send him to Syria. But don't worry about it. They got assurances from the Syrians that he wouldn't be tortured. Assurances from a government that our government says lies all the time. Assurances from a government that our government says tortures as a matter of routine. Assurances from a government that our government says practices state terrorism. Who in the Bush administration was foolish enough to believe in those assurances? We have to decide whether the Bush administration is cynical in lying to us and to itself that they believe those assurances, which I believe to be the case, or was foolish in believing assurances from a government that it says cannot be believed. I look forward, so the question really is, was the administration a fool or a knave here? I think the evidence is a knave and a continuing knave. I look forward to Mr. Arar's testimony and to the testimony of our expert witnesses. It is about time we expose this conduct to the light of day. This nation deserves to have its government act in a manner that is consistent with our laws and our values. And that it's not enough to say that this is a mistake and that we apologize. Not as long as the policy underlying it continues and we continue to claim the right to snatch people off the street, kidnap them, and send them to another government where we know they will be tortured. I hope one day to be able to apologize to Mr. Arar in person on American soil. I yield back the balance of my time.
I thank the gentleman, and now I turn to the ranking member from Arizona, Mr. Trent, on the subcommittee on the Constitution. And for housekeeping purposes, once we hear from, I will then introduce formally Mr. Arar for his statement, and then I will yield my time for questions to the other gentleman from Arizona, because I'm aware that he has time constraints. So with that, let me call on the ranking member, Mr. Franks.
Well, thank you, Mr. Chairman. And Mr. Chairman, first let me sincerely associate myself with the comments and opening statement of Ranking Member Rohrabacher. I want to also express my sincere regret to Mr. Arar for the tragedy that has befallen him, and want to be very clear on that point. Mr. Chairman, extraordinary rendition is a term used to refer to the extrajudicial transfer of a person from one state to another. And perhaps the most notable case is of rendition involved here is the one involving Mr. Maher Arar, a dual citizen of Canada and Syria. Mr. Arar filed suit in January 2004 against certain U.S. officials that he claims were responsible for rendering him to Syria. On February 16, 2006, the U.S. District Court for the Eastern District of New York dismissed Mr. Arar's case on a number of grounds, including that certain claims raised against U.S. officials implicated national security and foreign policy considerations. Separately, the Canadian government established a commission to investigate Canada's involvement in Mr. Arar's arrest and transfer to Syria. The final report of that commission, released in September 2006, concluded that Canadian officials provided U.S. authorities with inaccurate information regarding Mr. Arar that led to his transfer to Syria. The report made clear that the Canadian government had reason to be suspicious of Mr. Arar, as he seemed to be close to Abdullah al-Malki, who was believed to be a member of al-Qaeda. As the Canadian Commission stated in its report, quote, Canadian authorities properly considered Mr. Arar to be a person of interest in its investigation. Mr. al-Malki and Arar were seen walking together in the rain, conversing for about 20 minutes. Given Mr. al-Malki was a target of the investigation, it was reasonable for authorities to investigate Mr. Arar, unquote. Mr. Arar had even listed Mr. al-Malki as an emergency contact on his rental application, indicating they might have close ties. Despite these legitimate concerns, the Canadian's report itself indicates that Mr. Arar's ordeal was caused by Canadian officials providing the U.S. with inaccurate, negative information regarding Mr. Arar and that the threat he might pose to national security. Specifically, the Royal Canadian Mounted Police provided American authorities with information about Mr. Arar that was, quote, inaccurate and misleading, false, and that portrayed him in an unfairly negative fashion. Examples include the description of Mr. Arar as being a member of a, quote, Islamic extremist individuals suspected of being linked to the al-Qaeda terrorist movement. Several references to Mr. Arar as a, quote, suspect or, quote, principal subject or target or important figure, and the assertions that Mr. Arar had refused an interview with Canadian authorities. The report also discusses the facts that Canadian authorities sent to the FBI that concluded that, quote, Arar seemed to be connected to many of the targets of our investigation. Arar had been asked for an interview as a potential witness, but Arar sought legal counsel and declined. Arar soon after departed the country rather suddenly for Tunisia, unquote. The Canadian Commission concluded that this information was untrue and that, quote, it is very likely that in making the decisions to detain and remove Mr. Arar, American authorities relied on information about Mr. Arar provided by Canadian authorities, unquote. So what we're left with from the official investigation by Canada into this incident is that whatever decisions were made by American authorities, whatever they were driven by inaccurate information provided by Canadian authorities that cast Mr. Arar in a negative light. Mr. Chairman, I sincerely believe that the story of Mr. Arar will ultimately not be shown to be a failure of U.S. rendition policy, but instead an anomalous failure in the particular circumstances caused by false intelligence and information from Canada. And I sincerely and truly, with my heart, regret any injustice that may have occurred to Mr. Arar by any hands whatsoever in any country, and I very much want to hear his story today. So thank you, Mr. Chairman.
Thank you, Mr. Frank. And before we proceed to introduce our panel that is in Ottawa, I ask for unanimous consent for a statement submitted from Amnesty International to be entered into the record, and without objection, it is so entered. And now let me introduce our first panel, who, as I indicated, are participating in this hearing via video conference from Ottawa. Mr. Arar is a wireless technology consultant who spent time in Greater Boston, having worked with a software company in the town of Natick, which is within the congressional district of my colleague, who may or may not join us, Congressman Ed Markey. He was born in Syria and came to Canada in 1987 at the age of 17. He received his Canadian citizenship in 1991. He holds a bachelor's degree from McGill University in computer engineering and a master's degree from the University of Quebec in telecommunications. He is currently pursuing a PhD in wireless engineering at the University of Ottawa. He is married and has 2 children. Thank you very much, Mr. Arar, for agreeing to speak with us today. Our second witness on this panel is Kent Roach, a professor of law with cross appointments in criminology and political science at the University of Toronto. A fellow of the Royal Society of Canada, he has authored 9 books, including Constitutional Remedies in Canada. In recent years, Professor Roach has focused much of his work on anti-terrorism law and policy. He is the co-editor of Global Anti-Terrorism Law and Policy and the Security of Freedom, Essays on Canada's Anti-Terrorism Bill. Professor Roach was also appointed to the 5-person research advisory panel for the Arar Commission. Let's begin with the testimony of Mr. Arar. Please, sir, proceed.
Good afternoon, Chairman Delahunt and Chairman Nadler, ranking members Franks and Nora Bucker, members of both committees. Thank you for giving me this opportunity to speak to you today. Let me begin by telling you...
Mr. Arar, if you can just suspend for a moment and we can have someone from our staff lower the volume. I'm looking and I don't see any movement. He did it. Actually, the ranking member, Mr. Arar, is hard of hearing, and he's requested that we leave it there.
Is it okay now?
Let's proceed.
No audio now? Let me begin by telling you, Mr. Chairman, how grateful I am to you and other members of the committee for offering your apologies. I do hope that the government will eventually and officially apologize. Forgive me for not being with you in person. I am forced to appear by video link because the U.S. government prevents me from coming there. Even though 5 years have passed since my original detention, and I have never been charged with any crime in any country. Let me be clear, I am not a terrorist. I am not a member of Al-Qaeda or any other terrorist group. I am a father, a husband, and an engineer. I am also a victim of the immoral practice of extraordinary rendition. I'm here today to tell you about what happened to me and how I was detained and interrogated by the United States government, transported to Syria against my will, tortured, and kept there for a year. I'm here today because I believe it is my moral duty as a human being to help prevent what happened to me from happening to others. The America I see and I hear about today is not the same America I admired when I lived there from 1999 to early 2001. Back then, I decided to learn from the professional American business culture by taking a high-tech job in Boston that I hoped would eventually allow me to start my own business in Canada. In September 2002, I was returning to Canada for work from a family trip to Tunis, where my wife and children stayed behind with my ailing father-in-law. My return flight to Montreal connected through JFK Airport in New York. Upon viewing my valid Canadian passport, an immigration officer pulled me aside and took me to be fingerprinted and photographed. I asked to make a phone call, but my request was denied. Sometime later, officers from the FBI and the New York Police Department arrived and began to interrogate me. My repeated requests for a lawyer were all denied. I was told that I had no right to a lawyer because I was not an American citizen. The interrogation on that first day lasted about 8 hours, during which I was insulted and humiliated, and continued the next day, at the end of which they asked me to volunteer to go to Syria. Of course, I refused, and I told them that I wanted to go to Canada. I was then taken to the Metropolitan Detention Center in Brooklyn, where I was kept for the next 10 days. After 5 days of repeated requests, I was finally allowed to make a brief phone call to alert my family of my whereabouts. More than a week passed before I was allowed to finally meet briefly with a lawyer on October 5th. At 9 o'clock the next day at night, on a Sunday, I was informed that my lawyer was waiting to see me. I was taken out of my cell and into a room where about 7 people or 7 officials were waiting for me. To my surprise, my lawyer was not there. When I asked them where my lawyer was, they told me he refused to come. They questioned me for about 6 hours until 3 in the morning, and that was despite my repeated requests for my lawyer to be present and despite my request to see a judge. They mainly asked me why I did not want to go to Syria. I clearly and repeatedly told them that I was afraid I would be tortured there. I told them I would be tortured because I was being wrongly accused of being a member of Al-Qaeda. I also conveyed to them my fear of returning to Syria, given that I had not fulfilled my compulsory military service. My pleas fell on deaf ears. On October 8th, at 3 in the morning, I was awakened and told that they had decided to remove me to Syria. When I told them again about my fears of being tortured, they told me they were not the office that deals with the torture convention. By then it was becoming more and more clear to me that I was being sent to Syria for the purpose of being tortured. I was put on a private jet and flown to Jordan, then driven to Syria, and eventually ended up at the Palestine branch of the Syrian military intelligence on October 9th. There I was put in a dark underground cell that was more like a grave. It was 3 feet wide, 6 feet deep, and 7 feet high. Life in that cell was hell. I spent 10 months and 10 days in that grave. During the early days of my detention, I was interrogated and physically tortured. I was beaten with an electrical cable and threatened with a metal chair, the tire, and electric shocks. I was forced to falsely confess that I had been to Afghanistan. When I was not being beaten, I was put in a waiting room so that I could hear the screams of other prisoners. The cries of the women still haunt me the most. Over the next 10 months, the only time I left my cell was to be interrogated or for meetings with the Canadian consul. I was allowed to meet with the consul 7 times, but only in the controlled presence of Syrian officials. I was warned prior to those meetings not to say how I was being treated. During the last visit, however, I burst out yelling about the beatings and the horrible conditions I had been living in. After 374 days of torture and wrongful detention, I was finally released to Canadian Embassy officials on October 5th, 2003. These past few years have been a nightmare for me. Since my return to Canada, my physical pain has slowly healed, but the cognitive and psychological scars from my ordeal remain with me on a daily basis. I still have nightmares and recurring flashbacks. I have lost confidence in myself, and I live in constant fear of flying and being kidnapped again. I am not the same person that I was. I have come to accept this as part of my new life, but I want to make sure that no one else has to go through what I have gone through. In sharing my story and my experiences with you today, I hope that the effects of torturing a human being will be better understood. I also hope to convey how fragile our human rights have become and how easily they can be taken from us by the same governments that have sworn to protect them. Thank you very much. I look forward to answering your questions.
Well, thank you, Mr. Araf, for that very powerful testimony. Mr. Roach, would you please proceed?
I would like to extend my thanks to both committees for the invitation. As you heard, I was a member of the Research Advisory Committee for Justice O'Connor's report. Justice O'Connor's policy is to let his report speak for itself. There are 3 volumes in the report. It's available on the internet, and I do commend it to your attention. I'd like to say a little bit about what a commission of inquiry is in Canada. It is a very strong instrument of investigation and accountability. It enjoys de facto independence from the executive and legislative branch. Justice O'Connor sits on the Ontario Court of Appeal, a sitting judge. During the 2.5 years of the inquiry's work, 21,000 documents were subpoenaed, 83 witnesses were cross-examined, and 75 days of in-camera testimony and 45 days of public hearing. Justice O'Connor asked both the governments of Syria and the United States to participate in the inquiry process, but they declined. With respect to the main findings of Justice O'Connor, many of these have already been mentioned in the opening statements. Justice O'Connor found that there was nothing in all of the evidence that he looked at to indicate that Mr. Arar had committed any offense or any activities that constituted a threat to the security of Canada. He underlined that this should dispel any taint or suspicion that surrounds Mr. Arar. Justice O'Connor did say that Mr. Arar was a person of interest, but not a suspect in an RCMP terrorism investigation. Justice O'Connor found that the RCMP passed on inaccurate information to the United States that described not only Mr. Arar, but his wife, Dr. Monia Mazig, as, quote, Islamic extremist individuals suspected of being linked to al-Qaeda. Justice O'Connor concluded that there was no support for those damning and inflammatory conclusions. Justice O'Connor found that there was nothing in the possession of Canadian officials from the U.S., and there was much information sharing that indicated any link between Mr. Arar and al-Qaeda. Justice O'Connor found that Mr. Arar was not given prompt consular assistance and that there was a violation of the Vienna Convention on Consular Assistance because of the delay in providing access to a Canadian consular official while Mr. Arar was detained in New York. Justice O'Connor found that Canadian officials on October the 5th informed the FBI that Mr. Arar would not be charged and would be admitted back into Canada and that there were no links. And it was sometime after that the decision to remove Mr. Arar to Syria was made. Justice O'Connor found that Mr. Arar was tortured, held incommunicado for his first 2 weeks in Syria, tortured, beaten with a black cable, and held in in the grave-like cell that Mr. Arar has just described to you. In conclusion, I'd like to just talk about recommendations that Justice O'Connor made. He recognized the importance of information sharing between Canada and the United States, but stressed that that information must be accurate, must be precise, and must be reliable. He identified the danger of guilt by association in national security investigations. He identified the impossible position that a person is put in when they have to defend themselves against secret information that they do not know. He criticized the Canadian government for making national security confidentiality claims that were unwarranted and urged all governments to avoid the temptation to claim state secrets in order to protect a government from embarrassment. And finally, he concluded that torture for any purpose is so fundamental a violation of human dignity that it can never be legally justified, whether a person is a terrorist suspect or, as Mr. Arar was not, a terrorist suspect. And finally, that it produced unreliable evidence. Any statements obtained under torture would be unreliable. So it's my hope that both the terrible experience of Mr. Arar and the thorough investigation and report of Justice O'Connor will be of assistance to your two committees as you undertake this very important work. Thank you.
Thank you, Mr. Arar. I will now yield my time to the gentleman from Arizona, Mr. Flake. I then will go to the ranking member of the subcommittee, Mr. Rohrabacher, and then I will go to Mr. Nadler. Mr. Flake.
I thank the chairman for yielding me his time. I really appreciate it, having to catch a flight here soon. I've been troubled by this practice for a while, and certainly this case is the highest profile case. And I have mentioned to the chairman a number of occasions desire to work on legislation in this regard. I know there's one piece of legislation out there, but we definitely need to address this practice. I'd just like to ask Mr. Arar, with regard to, I know you filed suit, and there's there's been some contact there, but what has been the response? What have you gotten out of U.S. officials? What has officially been said about your case by U.S. officials?
I think the government so far in courts has taken a very strong position, and they have been fighting my case not to proceed. We appealed the decision, and it's the oral argument will be heard November 9th, this coming month.
Before going to court, was there any communication or any dialogue or any response from the U.S.? And no apology was offered?
No apology.
During your time in Syria...
No explanation. No explanation whatsoever. Even our government has asked the U.S. to come clean about what happened. And the most fundamental question that has not been answered yet is why did the U.S. government decide to send me to Syria and not to Canada?
When you were in Syria... Oh, go ahead. Well, I'm sorry.
Today is that the Canadian government, according to the findings, has not objected to me coming back to Canada.
When you were in Syria, you mentioned you met with a Canadian consul 7 times. Was there any attempt made to contact U.S. officials by the Canadians, or any involvement at that time during your incarceration? What was your understanding in terms of U.S. involvement? Had they washed their hands of it by then?
I think they washed their hands of it by then, yes.
What, in your view, what does this do to U.S. credibility abroad to have this kind of practice, or see it play out in your case? You've been home now for a while and have been able to view this, I guess, or how the world views it. What are your thoughts there?
Well, I'll tell you about my own experience. I decided to go live in the States for a while because I wanted to learn the business culture so that I could start my company later on. And I never made the distinction between Canada as a society and the U.S., both civilized nations, both affording their people due process and respect for human rights. That's why when I was arrested and sent to Syria against my will, it really shocked me completely. I couldn't believe what was happening. Definitely after I was released, I was taken to a better facility before I was released. I spoken to other prison mates about the situation, and I could tell you many people were surprised to find out that the American government would do such a thing. You know, for them, how could they believe that now the U.S. is going to help them establish democracy? That was very, very clear in terms of credibility. The U.S. has no more credibility now, at least to some of the discussions I had.
Right. Well, thank you, and my time is about out. I just want to offer my own apology for you and for your experience, and I hope that we can use the experience that you've had to help change the practice. I yield back.
Thank you very much.
I now yield to the ranking member of the committee, Mr. Rohrabacher of California.
Well, thank you very much, Mr. Chairman. Mr. Rahr, what date was it when you originally were taken into custody at JFK? Do you remember what date that was?
September 26, 2002.
September 26th, all right. Okay, it just dawned on me that earlier when we were looking at this that September was just 1 year later after 9/11. And do you think that what you went through reflects the values of the American and Canadian people? Or do you accept the fact that this was a mistake, and that the Canadians have already apologized, a lot of Americans, but our government has yet to apologize? But do you accept that as a reflection that we, as a people, do not really go along with the type of treatment that you went through for someone who is an innocent person and someone who is not engaged in terrorism?
Well, I can tell you I lived in the States for almost 2 years in Massachusetts, and the people I've worked with, my former colleagues, they're very nice people. They're had the same values that I had as a Canadian. But even them, they were shocked after they learned that I was sent to Syria. They started sending letters to senators and Congress people. What is troubling about what happened to me I would have believed this is an innocent mistake if this was not happening to others. There seems to be a pattern where the number we heard, hundreds of people are being sent to countries where they are tortured. And this is, again, regardless whether those people are true terrorists or not. To send people to torture under any circumstances is wrong. We now know that most of the information the Americans had is inaccurate or false. But even if all this information was true, it does not justify sending me to Syria. I should have been sent back to Canada.
I think that's a central one.
And what is troubling, even if we assume this was an innocent mistake, a civilized country like the United States, they should take action to try to remedy the situation. They should not take the position that they have been taking in courts to try to dismiss my case and using state secrets claims. So I call that the abuse. It's still ongoing because they have not allowed me to pursue justice in courts. Normally, when any person is wronged, the best place to go is to courts. But unfortunately, so far, I have not been able to reestablish trust in the system because of this. So not only I was sent against my will then,
right,
but I'm not being given the chance to clear my name in the States and to try to obtain justice.
You know, many of us believe that we are in a state of war in the United States. I mean, we have after all, suffered the reality of what happened perhaps just 1 year before you were taken into custody, where 3,000 of our citizens were slaughtered right in front of us. And by the way, those terrorists that slaughtered those 3,000 Americans, their intention was to slaughter 50,000 to 100,000 people, not 3,000. Just that they got the timing wrong in terms of when those planes landed in those buildings. And that does, when you are at war with people who are willing to slaughter those numbers of people, that does affect the way you do business. And when you are trying to combat that type of terrorism, innocent people get hurt, and you were one of those innocent people. And the difference, I think, is not, the difference between a free society and let's say an honorable society, is not whether they've committed themselves to getting those terrorists, but what they do when they make a mistake and whether they acknowledge that mistake. And I would have to suggest to you that the primary injustice that has been done to you is that our country made a mistake and it's not willing to own up to it now. Not that after, less than a year and 1 month after 9/11, that we made a serious error when trying to track down people who were connected to Al-Qaeda, which was the terrorist network that had just slaughtered our people. So whether or not, now you are a father? You have children?
Yes.
How many children do you have?
Yes. I have two, a daughter and a son.
And how old are they?
My daughter is 10 years old and my son is 5 years old.
Right. I have 3 children, and they're all, my life was blessed with triplets 3.5 years ago, 1 boy and 2 girls. And I would hope that whatever our government does, that your children are safe and my children are safe. And I would hope that, number one, I don't believe that we go out and our people who were involved in the rendition program went out and just, we're going to go out and get somebody who is an ethnic Arab or is a Muslim, and we're just going to use this person as an example as some sort of punishment against other Arabs who may have committed violent crimes against us. I don't believe that's what it was. I think they made a mistake. They did not do a professional job. The Canadians who provided them the information about your case did not do their professional job, and we should own up to that. But to the degree that we continue a program and that will make sure that a terrorist doesn't explode a bomb in the city where your children are located or my children are located, I think it's important that we understand that that's the stake. And I sympathize with your family because your children just went through, and I know, a horrendous situation where you now have, and I can understand the psychological scars that you bear. And I'm sorry about that. But I want to make sure that we all know that the safety of America's children and families will not be furthered for us to step away from responsibilities of conducting operations, even knowing mistakes will be made within those operations. So with that said, Mr. Chairman, I don't know what more I can say on this. I think that he's made his case. I think it is, by the way, the man that you were accused of, Mr. Al-Maliki, is that his name?
Yes, Mr. Al-Maliki.
Is he part of the Al-Qaeda terrorist network, or is he just someone that, again, was misidentified?
Let's establish facts here. Mr. Al-Maliki is back in Canada, sound and safe. Mm-hmm. He has not been charged with any crime in any country. In fact, all the people they try to associate me with, they have not been charged with any crime in any country. So this is a fact. And this is despite 5 or 6 years of intensive international investigation. So he's back in Canada. He's not charged with any crime. And I could tell you definitely that my relationship with him was overstated.
Okay. And you don't believe that he is a part of a terrorist network then? You think that's a mistake?
I can tell you that I do not know anyone who belongs to any terrorist group, okay, whether it's Al-Qaeda or other terrorist groups.
Okay, well, I accept that, and I'm sorry that you weren't able to come here today. Again, that reflects an arrogance that I don't like to see in our government, the fact that you're kept on the list so you can't even come here and explain your story, and that doesn't reflect a good attitude. And to the degree that I may disagree with you about to what degrees we should go in a rendition program or any other effort to make sure that terrorists don't blow up buildings in the United States or blow up a nuclear weapon or something like that, or a chemical biological weapon. To the degree that we are trying to do that, we may disagree to how far we can carry that fight. But when we make a mistake in any endeavor, we should admit it. And our government doesn't seem to have admitted that now, and not letting you here adds insult to injury. And I think you should have been permitted to, you should be taken off that list, given compensation, be permitted to come here and tell your story. And in the meantime, those of us who do believe there's a fundamental difference between the terrorists and democratic peoples, that we'll try to make it a better world. But sometimes, you know, when you're at war, mistakes happen, people die, and as I told in my opening statement, we have friendly fire. People are killed by friendly fire all the time in every military operation we have. But if we never conducted those military operations, we might have put the whole people of the United States, including our children and your children in Canada even, in jeopardy. So thank you for your testimony. Your ordeal. Look, I have visited some of the jails where communists kept their political prisoners in Hungary and elsewhere, and what you were describing is just a gruesome reminder of that type of tyranny and mindset. And so I'm sorry that you had to go through that, and hopefully no innocent person will ever have to go through that. So thank you very much, Mr. Chairman.
I thank the gentleman, and I'm going to yield to my colleague from New York. But before I do, I think I should note for the record that it's my understanding that there is a similar inquiry, independent inquiry proceeding regarding the case of Mr. Al-Maliki, and I have read reports that speculate that the conclusions will be similar similar to the conclusion in the case of Mr. Arar, because the reality is that the Canadians have owned up. It's not on the Canadians. They've acknowledged their mistakes. It's this nation and this government, this administration, that has failed. With that, I yield to the gentleman from New York.
I thank the gentleman. Before I start, on behalf of our colleague, Mr. Watt from North Carolina, who had to leave, I'd like to submit this statement for the record. I thank you. And let me also say, before beginning my questioning of Mr. Arar, that I have to disagree with my distinguished friend from California. This is not simply a case of a mistake in sending Mr. Arar to Syria or in getting the wrong person. It certainly was that. Nor is it simply a mistake of refusing to acknowledge error after the fact, although it is certainly that too. The mistake here is cutting constitutional and legal corners, doing things that are prohibited by our laws, denying due process, winking at torture, hiding evidence and mistakes behind a wall of state secrets so as to prevent a proper inquiry such as occurred in Canada. The administration, by sending Mr. Arar to Syria, was outsourcing torture. They wanted him tortured, quite obviously. And maybe they got the wrong guy, but even if they had the right guy, we shouldn't be engaging in torture. We shouldn't be winking at torture. We knew perfectly well that any assurances from the Syrian government that they would not engage in torture were worthless. Our government has said so many times. And you don't have to take my word for it. Look at the State Department reports annually. So I think the mistake here was disobeying our obligations under the Convention Against Torture, disobeying our obligations under the law to provide some due process under a dozen different laws, winking at torture, and now, after the fact, refusing to admit error and getting away with it by hiding behind a shield of state secrets and denying the right of the courts to do a proper inquiry. So this is far more than just an error and making a mistake. It's a fundamental denial of due process. It's a fundamental subversion of our laws and our protections and our liberties, and this is the perfect example of what happens when you subvert our constitutional protections. Now, Mr. Arar, let me ask you one preliminary question. Were you ever at an al-Qaeda training camp in Pakistan or Afghanistan?
No.
Were you ever in Afghanistan or Pakistan?
No.
Given those facts, if the United States government believed that you were, can you think of any reason why they might think so?
Why they would think that I had been to Afghanistan?
Yes, or that you had been in a training camp.
Frankly, I don't remember being asked in the United States about that. The only time that this came up was in Syria, and I falsely confessed in Syria under torture.
So if the American government believed that you were at an al-Qaeda training camp in Syria, in Afghanistan or Pakistan, it might be, in the absence of any other knowledge, it would be because such a false admission was tortured out of you in Syria.
Yes.
Thank you. Now, you were detained at a facility in my district. For that and for everything else, I again apologize. Now, what reasons were given for denying you access to a phone call for 5 days or access to an attorney?
No reason whatsoever. All I know is I kept asking for a phone call and for access to a lawyer. I was always denied. And frankly, even the brief 2-minute call I had with my mother-in-law, every time they served me a meal, I had to go and bug them and say, I want to make a phone call, and until they granted me that brief phone call.
And so you were never given a reason for being denied access to a lawyer or to a phone call? No. And how would you characterize your treatment at the hands of U.S. agents before you were turned over to Syria?
Can you repeat the question, please?
How would you characterize your treatment at the hands of U.S. agents while you were in U.S. custody?
Well, First of all, it was quite shocking for me not to have allowed me access to a lawyer or even a basic phone call to let my family know where I was. I was disappeared for a complete week. My mom did not know where I was. My wife did not know where I was, whether I was alive or dead. And that alone was shocking to me. Just a simple phone call to tell them about what was going on. They didn't allow me proper access to a lawyer. Even when they sent me to MDC, they kept me in a maximum security prison, a section of that detention center, where I was confined to a solitary confinement for almost over a week. They didn't allow me access to the recreation. Other than the fact that I was, not given toothpaste or even basic things. They didn't even allow me to have a pen. Every time I was transported inside that prison, they used to videotape me. Whenever I objected about my religious beliefs, they did not really care. For instance, during this 6-hour interview where I asked for my lawyer to be present, I asked them to be allowed to go back to my cell for my prayer, and they didn't allow me to do this. So it's still actually shocking to me that how come they have treated me like that.
I see. My time is about to expire, so I have just one question for you, one more question, and one question for Mr. Roach. When you expressed fear about being sent to Syria, and you told them that if you were sent to Syria, you expected to be tortured, what was the response to your statement that you thought you'd be tortured in Syria? And what, if anything, were you told about our obligation under the Convention Against Torture?
I objected. I told them about my fears of being tortured, both during the 6-hour interview on a Sunday and when they took me from MDC and read me the decision. In the first interview, they did not really seem to care. In fact, I remember vividly at the end when it became very clear that was the direction where they were going. I told them this. I told them, what are you going to tell my kids when they grow up if you ever decide to send me to Syria? You think my kids will like the United States like I do now? In fact, I told them I appealed to President Bush. I appealed to the American people. They did not seem to care. When they read me the decision, the final decision that they were going to send me to Syria, I told them, and I cried, and I said, how come you do that? You know I'm going to be tortured there. I told you this many times. And she read me, the person who was there read me part of that decision where she basically said that the INS is not the office that deals with the torture convention. Basically, for me, what that really meant is we really don't care. We're sending you to Syria for that specific purpose.
Thank you. Mr. Roach, I have one question, if I may. You were intimately involved in the Canadian Commission's need to balance the search for the facts in Mr. Arar's case and the need to protect sensitive national security information at the same time. Now, in cases brought here against U.S. officials, the same concerns have been raised. And it's a case, in this case, in the discussion we're having in Congress now about immunizing telecommunications companies from perhaps having disobeyed our laws with respect to wiretapping previously, and we're told that well, we can't. We have to immunize them because to defend them might reveal state secrets and so forth. The same concerns have been raised. Is there anything you have learned that might provide some insight as we also work toward achieving a balance between respect and protection of individual rights and legitimate national security needs as to how to do this?
Yeah. I think it's very important to be precise about the reasons for protecting secrets, because there are some very good reasons. ongoing investigations, vulnerable sources that if their identity were revealed could be killed or tortured themselves. But I really think we have to move away from the broad generalities of national security, because one of the things that Justice O'Connor found in his report is that there is a temptation for governments to claim state secrets to protect themselves from embarrassment. And as you can see from a 3-volume report that the government even agreed, and then there was litigation over the remaining part. But even during contemporary national security investigations, much can be made public without revealing this small, legitimate core of state secrets that have to be kept secret.
Well, let me ask you one further thing. In this case, we are told by our government that Mr. Maher is a dangerous terrorist. I don't know if they've actually said it in so many words, but they said he can't be admitted to this country, which is another way of saying he's a dangerous terrorist. Presumably, the government has some evidence or reason to believe that, which they will not reveal to us, except under secret conditions, which certainly will not reveal to the public, and came into court and said you can't try the case because it'll reveal sensitive state secrets. Given what you know about the case, can you imagine that there's anything that might be relevant here that couldn't be revealed safely, that could not be revealed safely?
Well, I mean, it's difficult to answer that question. That's the dilemma of secret information, that you're put into an impossible position. What I can say, though, is that there was nothing, Justice O'Connor found there was nothing in Canadian possession that indicated any links. And so if I would hope that if there was a smoking gun in the United States, it would be shared with the Canadian government. But there was no findings of that. So I think it really does underline the incredible catch-22 position that people are put in when the government says, we have information that incriminates you, but nobody can see it because it is secret.
Thank you very much. I yield back.
I yield to the gentleman from Arizona, the ranking member, Mr. Frank.
Well, thank you, Mr. Chairman. Mr. Chairman, I will be brief. Mr. Arar, is there anything else that, other than that you've already said that you'd like to have a chance to say, that it would just be something that you'd like to pass along to us, to give you, rather than me posing a question to you? Is there anything that you think that we're missing here, or that we don't understand, or that is just something in your own heart that you'd like to relay?
A follow-up on the previous question, I would like to emphasize the fact that our Minister of Public Safety went down to the States a couple of months ago and looked at the U.S. information, and he clearly publicly said that there was nothing there that would, according to his opinion, would justify placing me on a watch list. Actually, if I remember correctly, he went further to say on any watch list, not only the American watch list.
Let me yield for a moment.
So what I'm saying, instead of U.S. officials hiding behind state secret, and whether we like it or not, this has the effect of smear campaign on my already damaged reputation. Instead of doing this, I would hope that they would become more transparent and let my lawsuit proceed to discovery. And if they have any evidence or suspicions, then that will become, I will have a chance to defend myself. But the way they're doing it right now, it's not the proper way of doing it. It's unfortunate. Normally those kind of actions are attributed to officials in dictatorships and not in countries like the United States of America.